Boss is going to get out there, show you everything. You don't get to keep copies of things by law. He doesn't get to hand you a police report and you keep it. That's part of the law. So he can go over that with you, read what it says to you, show you the video, and then you can make your decision. Go back with the bailiff. Nope, I'm done today. Go back with the bailiff.
Right from the start, this hearing takes an unexpected turn. The judge isn't rushing the process. She's making sure the defendant fully understands the charges before anything moves forward. That might seem routine, but in court, understanding your rights isn't optional. It's one of the most important protections the justice system provides.
I don't understand how you can give somebody 4 years for an accident.
Good morning. Are you Tan? You're Tan Van Pham?
Yes, ma'am.
And Mr. Pham, you are charged in cause number 25 DCCR 0909 with the state jail felony offense of theft of property from May 3rd of 2025. If you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in state jail prison. Do you understand?
Yes. Depend on my lawyer. If she say yes, I have to say yes, ma'am.
No, I want to make sure you understand. And do you understand? Do you need an interpreter? Would that be better?
Yeah, that's better because I don't understand English very well.
Well, we've been able to communicate.
You have.
You know,
the whole time.
Yes, ma'am.
So, Mr. Pham, if you go, I just want to make sure in all of your cases, every single case, you've got 25 DCCR 0909, 25 DCCR 1039, 26 DCCR 0353, 54, 55, and then we've got 25 DCCR 0782 and 0785. All of those cases charge you with theft of property with previous convictions, which means if you're found guilty, the range of punishment, you could go to prison for a minimum of 6 months up to 2 years in each of those cases. Do you understand that?
I know, but I don't do like that, you know.
I just want to make sure you understand that if a jury finds you guilty, what the range of punishment is. What could happen?
I don't know what it means because my English not too well, you know. But I don't do like that.
Now, this is exactly why interpreters matter in criminal court. Instead of guessing whether the defendant understands, the judge presses pause. A conviction means nothing if the accused couldn't properly understand the proceedings. Fairness always comes before speed, and that's a principle every courtroom should follow.
Reset it 1 week. Let's get figure out who we can get as an interpreter, please. You speak Vietnamese?
Yeah, I speak with them.
Okay, we'll see you next week. We'll figure it out.
Okay, thank you, ma'am.
Yes.
Thank you so much.
No, yeah. Right. And then Mr. Rojas, Justice Lars.
Yes, ma'am. He wants to talk to the
He wants to do what?
talk to the court again. He wouldn't.
Let's get Mr. Larzo out real quick, please.
Maybe if I nick you off in the base, that's what it is.
You see, like the Price is Right. Remember that game the little guy goes.
The mountain climber.
Little mountain man's going.
That's it. There's so many words are allowed. Yeah. All right, Mr. Larzo, what's going on?
I'm going ahead. I want to request a lawyer. He's not representative.
Here's the thing: you don't get to do that. So here's where we are. Mr. Rojas is a great lawyer. He's not, just because
Can I speak?
Nope, not while I'm talking. I already gave you an opportunity earlier, and I'm going to give you an opportunity in a minute. But I want you to listen carefully to what I have to say first, okay? Mr. Rojas is telling you what the district attorney's office is offering. You don't have to like it. It doesn't mean he's a bad attorney. And another attorney is not going to come get a different offer.
Okay.
So
Here's where the tension really starts building. The defendant wants a new lawyer, but that's not a decision the court grants just because someone is frustrated. The judge has to determine whether there's an actual breakdown in representation, not simply disagreement over legal advice. What would you do in this situation?
Ms. Malfino, is there any reason that you would know of that offer that you have made would change?
No, it will only go up.
So you're where you are. So either you accept that offer or we set your case for trial. Once your case is set for, hang on,
I want a new lawyer. I don't.
hold on. I understand, but
You
listen,
want to let me speak, man? Please, can I speak? Please?
I'm going to let you speak, but I'm going to give you what your options are, okay?
I just want. All I want is a. What I'm saying, you trying to say trial, this and that. I haven't even seen my discovery evidence. You saying he's a good lawyer, but he haven't even shown me no evidence. So on my case, how can you speak and say he already told me the other day that he working for the DA? He
I'm
already said.
sure
I said you haven't. He have not one asked me what happened. He haven't even got my side of the story. Have you got my side of the story? Have I told you what happened in this case? Can you tell this person what I told you?
Mr. Larzo, you're not in charge and you're
I'm
not
not saying
asking
I'm not in
questions.
charge, but what I'm saying is, how can he say he can represent me and he's ain't done nothing but come to me and say the DA said this, the police report said this. He has not.
That's the evidence. That's
the
what he's
evidence.
telling you the evidence is what's in.
That's what the police report said, but he hasn't asked me my side.
And here's the thing, your side is important if you're going to, if you didn't do it, what his job is to tell you this is the evidence they have against you. You can take this deal, or if you say you didn't do it, you can go to trial. So if you're saying you didn't do
This exchange highlights one of the biggest misconceptions people have about criminal cases. Your attorney's job isn't to tell you what you want to hear. It's to explain the evidence, the risks, and every legal option available. Sometimes the truth is uncomfortable, but that's exactly what effective representation looks like.
it, then let's get a jury to determine if you did it or not.
I haven't seen no police report. I haven't seen no body cam footage. I haven't seen no evidence to where I can tell you if I'm ready to go to trial.
Is there media in this
Judge,
case?
if, as Mr. Rojas does in every case, he has requested and reviewed the discovery well in advance.
Do you want, let's do this. Do you have some media?
Judge, I have requested the media. What I told Mr. Larzo yesterday when he told me he wanted to watch the video, I told him we could reset the date to look at the video. He just said he didn't want to do that. He just wanted to come in and ask for a new lawyer.
I want to, because you now represent me effectively. You come to me and tell me the DA said this.
Mr. Larzo, he's just said that yesterday he would bring the video. Don't talk over me. He would bring the video for you to watch. I'm going to reset your case for 2 weeks. He's going to bring the information. You can watch it and you can make your decision. The offer is what the offer is. The DA's already said that. I don't care if you take it or if you don't take it. Take it, fine. Don't take it. We'll get your case set for trial. You need to be respectful. Mr. Rojas is going to get out there, show you everything. You don't get to keep copies of things by law. He doesn't get to hand you a police report and you keep it. That's part of the law. So he can go over that with you, read what it says to you, show you the video, and then you can make your decision. Go back with the bailiff.
May I ask a question,
Go,
please?
nope, I'm done today. Go back with the
I'm not
bailiff.
understanding how you can give somebody 4 years for an aggravated charge and try to offer me 5 years for non-aggravated.
He's not happy.
DeMarcus Elam, Miss. Wait, hold on. Let me. Mr. Burbank, what are you doing on Mouton?
Hi, Mr. Mouton.
I know. What's the announcements?
I'm still on discovery. I just got appointed and I've talked to her. I think also based on that, I may need to have her evaluated somewhere between here and there. My request, based on the circumstances.
What?
Evaluate.
Somewhere between here and there?
Yeah, well, my motion is here between here and there. It's the evaluation. It's coming. Like
Okay.
Today or tomorrow.
Okay. We'll reset this Mouton.
And I've talked to her. She knows what's going on and
All right. Yeah, if you'll make sure you get that in,
She's happy.
we will get her evaluated as quickly as possible.
maybe I can convince Mr. Smith to.
DeMarcus Elam. Mr. Smith, you've got DeMarcus Elam, writ hearing. Good morning. Are you DeMarcus Elam?
Yes, ma'am.
And this is cause number 26, DCCR 1221.
Now the courtroom shifts into a much more serious case. Murder charges immediately raise the stakes, and every procedural decision becomes even more critical. Bond requests, legal filings, and courtroom strategy suddenly carry enormous consequences. This is where every step must follow the law with absolute precision.
Mr. Elam is charged with the first-degree felony offense of murder, and Mr. Reynolds was appointed as attorney. Ms. Holmes is stepping in to help out on that as well, and they have filed a writ requesting for a reduction in Mr. Elam's bond, which is currently set. Oh.
Yes.
Oh.
Yes, I believe Mr. Elam.
Did I know that ahead of time? No, I guess not, because I'm not gonna. So here's the thing: when you have an attorney, you don't get to have what we call dual representation. So if you, and I don't mind.
I think if I could clarify, it was filed pre-indictment. I'm not sure when Mr. Reynolds was placed on it, but Mr. Elam had filed the writ prior to being indicted, and then after the writ was filed, his case was indicted.
So it's been indicted at this point.
Yes, ma'am.
Okay. So here's what I'm going to do. What's the bond currently set at?
$2 million.
Okay.
This final ruling is a perfect reminder that in court, using the correct legal procedure matters just as much as the argument itself. The judge isn't rejecting the request. She's explaining that it must be filed the proper way. Justice isn't just about outcomes. It's about making sure every case follows the rules from beginning to end.
So what I'd like to do, I'm not going to, because the case has been indicted, at this point, a writ is probably not the appropriate tool. I would think it would just be a motion for a bond reduction. Ms. Holmes can talk with Mr. Reynolds. They can get that filed. They're going to file things on your behalf, okay? And so I understand that you were waiting on an indictment, but that's been taken care of now. But you don't get to file something if you have an attorney. I'm going to take what they filed. So let's get a bond reduction. Ms. Holmes will get that filed for you. I'll reset the case 1 week, but I think we need to have the appropriate tool moving forward legally. Let's do 2 weeks, and we'll have a bond hearing. If the state has any evidence, that'll give them some time to bring anybody, if you wish, on a bond reduction hearing. Okay, so we'll see you back in 2 weeks.
Okay.
Yeah. Yeah.
Now the courtroom shifts into a much more serious case. Murder charges immediately raise the stakes, and every procedural decision becomes even more critical. Bond requests, legal filings, and courtroom strategy suddenly carry enormous consequences. This is where every step must follow the law with absolute precision. This final ruling is a perfect reminder that in court, using the correct legal procedure matters just as much as the argument itself. The judge isn't rejecting the request. She's explaining that it must be filed the proper way. Justice isn't just about outcomes. It's about making sure every case follows the rules from beginning to end.